Prominent legal practitioners in the country have expressed deep concern over the unduly long delays in justice delivery at the Supreme Court, saying that it is a sign of the worsening justice administration in the country. The lawyers, including members of the inner bar, were reacting to a recent pronouncement by the Chief Justice of Nigeria, Justice Walter Onoge, that the Supreme Court diary is already filled up with appeals slated for hearing up to the year 2021. Joining us on the News Hour now is lawyer Ahmed Akanbi to take a look at some of these issues. Well, Ahmed, it's good to have you join us right now.
Thank you very much.
Thank you for joining us.
Now, those of us, let me say, who are laymen, who are not as learned, when they say that appeals in the Supreme Court or the diary has been filled up until 2021, not everyone is going to understand that. How cumbersome is that? How difficult or how complex are those issues? Make us understand.
Well, it's a frightening position, because what it simply means is that if you get to file an appeal at the Supreme Court now, there's no guarantee that your appeal will be heard before 2021. One of the fundamental principles of law is that justice delayed is justice denied. Most litigants presently have virtually lost confidence in the judicial process, because when a client comes to you, the first question the client will ask you is, how soon do you think my case will be concluded? And for me, I think as lawyers, we should be deeply worried. If things are allowed to continue to degenerate to worse levels, sooner than later, we might find ourselves out of work.
Shouldn't there be some sort of reform in the judiciary as to what sort of cases should go to the Supreme Court?
Absolutely, there should be a lot of reforms, both constitutional, both institutional, and even in terms of the human capacity. Constitutional in the sense that the Constitution provides that, gives the right of appeal to all the way from the High Court to the Court of Appeal to the Supreme Court. In certain other jurisdictions, like in the United States, for instance, there are very few cases go all the way to the Supreme Court of the United States. In Nigeria, I don't see why certain categories of cases should go all the way to the Supreme Court, such as cases involving commercial disputes, such as matrimonial causes, even chieftaincy matters, even land matters. But cases that deal with possibly an infraction of the Constitution or an interpretation of the Constitution can be allowed to go all the way to the Supreme Court. Cases that deal with life, matters of life and death, should be allowed to go all the way to the Supreme Court. But these things don't come easy. It entails the process of constitutional amendment. And I think the challenge for us as lawyers, particularly through the NBA, is to be able to lobby the legislature to do the needful. Okay. So definitely our destiny lies in our hands.
Well, there are certain calls for states to begin to have their own Supreme Court within their own jurisdiction, as the kid, like she was mentioning earlier. Now, from the records or reports we have is that appeals between 2006 and 2009 are the ones that constitute or are pending until or filled up the diary until 2021.
Absolutely.
And between 2010 and 2018. Those ones have to be allotted time, appeal and determination of their dates after 2020, from 2022. And it means that in all of these cases, to clear all the cases on ground as at today, will take until 2028.
Absolutely.
That's a very long period of time. Now, make us understand, what factors, what real factors are responsible for these delays?
Well, some factors are traceable to lawyers. Some are traceable to the institution itself. Some are even traceable to the Constitution. At present, the Supreme Court has about 5,000 cases to contend with, and we have just about 16 justices of the Supreme Court. More often than not, I ask myself, how do they even cope? And that is why most of our judges, the moment they're retired, they can hardly enjoy their retirement in peace. It's either they have to contend with one ailment or the other. I think we need to reduce the number of cases that go to the Supreme Court. From the statistics that was given by the Chief Justice of Nigeria, my Lord, the Honorable Justice Walter Onoge, 70% of the cases that the Supreme Court has to contend with are interlocutory appeals. We need to have reforms where interlocutory appeals will be subsumed with the hearing of the main appeal. because it can be terribly distracting. Either somebody somewhere is challenging the jurisdiction of a court, or somebody is filing an application to amend an irregular process or for an extension of time to bring a process in that has been filed out of time. These interlocutory applications can be terribly distracting. The Supreme Court should be left to deal with the meat of the matter. That is the substance of the law. I don't see why interlocutory applications should not be made to end at the Court of Appeal.
Exactly, and not get to the Supreme Court.
And not get to the Supreme Court.
All right, this issue of reforms, and it apparently seems to be the only solution we have to establish Supreme Courts in all states of the Federation. But how feasible or how much of a task will this be?
It's very much feasible. All you need to do is to amend the Constitution. If I have a land matter in Abeokuta, for instance, I don't see why I have to go all the way to Abuja to agitate my mind or to ventilate my grievance over whatever issues I'm bothered with. These matters should be allowed to terminate at the state level. And the call for state Supreme Courts it's very urgent. It is needful. It is the way to go. 16 justices of the Supreme Court, I'm sorry to say, cannot deal with the myriad of cases that emanate from all the states. And something has to be done.
We understand about 8,000 cases are pending. All right, we have to leave you here now. Lawyer Ahmed Akanbi, thank you very much for coming on the program.
Thank you for being here.